guns. It's one of the most divisive issues in America today, and the stakes are incredibly high.
One of the deadliest school shootings in U.S. history at an elementary school in Uvalde, Texas.
Even though I've lived in New York for 7 years, a place that's pretty hostile toward guns, I actually grew up duck hunting in Arkansas and have owned a gun most of my life. I really do understand both sides of this debate, but here's the interesting thing. We may not even have had a personal right to own a gun until 2008. This is Think Again with me, Andrew Stern, where I take you every step of the way as I dig into compelling, complex, or controversial topics that make us wonder, do we need to think again? As with basically anything that has to do with laws or rights in this country, it all comes down to language. So let's take a look at the Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. If we set aside the moral issue and just focus on the legal question of whether or not we have a personal right to own a gun, there's really two main things that people disagree on. One, was this first part, commonly called the militia clause, designed to limit gun ownership only to people who are actively serving in the militia, which today would be the National Guard? And two, what does keep and bear arms actually mean? Or more specifically, what did it mean in 1791 when the amendment was written? Because that second question has gotten a lot more heated in the last year or so, if you can believe it, because of this weird sounding field of research called Corpus linguistics, which we'll get into in a bit. Anyway, while today we might think the Second Amendment protects our personal right to own a gun, a lot of experts would tell you that wasn't the case for most of US history. For basically 200 years, the Second Amendment was commonly understood to link gun ownership to militia service. And that understanding wasn't even really challenged at the Supreme Court until the eve of World War II. In 1939, two bank robbers in my home state of Arkansas tried to claim they had a Second Amendment right to own a sawed-off shotgun. A unanimous Supreme Court said, nice try. There's no way you can link a sawed-off shotgun to militia service. So the government can make that particular gun illegal if it wants to. So almost 150 years after the Second Amendment was ratified, this ruling kind of confirmed the common understanding of it. The government didn't have to regulate or prohibit firearm ownership, but it could if it wanted to, because the right was pretty well understood to be tied to some sort of militia service. And this interpretation held for another 50 years or so.
There was no mention of personal self-defense at all in the Constitution, in the Second Amendment. It was basically understood to mean carrying arms in the context of some kind of military service.
So how did we go from a common understanding of the Second Amendment that linked gun ownership to the militia, to where we are today? Because the Supreme Court case that actually changed all of this didn't even happen until 2008. But by the time we got there, most Americans already thought the right was personal, not militia-based. And for that, you can mostly thank the NRA. From the late 1960s to today, the NRA went on the offensive in ads, in speeches, in TV appearances, pushing the narrative that you have a Second Amendment right to own a gun, and the government's trying to take it away from you.
Their goal is to eliminate the Second Amendment and our firearms freedoms so they can eradicate all individual freedoms.
All right, so our timeline is all over the place by this point. We have the Constitution, a Supreme Court case in 1939, the NRA from the 60s to today, another court case in 2008. Yet somehow I can't even explain how we ended up with a personal right to own guns without going back to 2003. Because that's when these guys decided it was time to take on the militia clause and prove, once and for all, that it did not limit your personal right to own a gun.
The three of us litigated the Heller versus District of Columbia case.
The three being Clark Neely, Alan Gura, and Bob Levy. Bob is the chairman of the most influential libertarian think tank in the country. The fourth guy in that photo is Dick Heller. He was their model case. Heller was a special police officer in Washington, D.C., which meant that he carried a gun for work. But he also wanted to own a handgun at home for what he said was self-defense. But because DC had a law on the books that banned all handguns, he wasn't allowed to have one.
DC was a particular ripe place to litigate Second Amendment because they had the most draconian gun control regime in the country. And yet they had the highest rate of gun violence in the country.
So, thanks to Bob and his colleagues, the Heller case winds its way to the Supreme Court, and we end up with the first definitive ruling on whether or not we have a personal right to own a gun. The court started with the militia clause.
The militia clause was a prefatory clause to give one of the main reasons to recognize the right to keep and bear arms.
Stephen Halbrook wrote a hugely influential opinion for a bunch of senators and congressmen in the Heller case. He's saying that the militia clause announces one important reason for why people should be allowed to own guns, but it's not the only reason why.
Invariably, if you refer to the right to bear arms at the time of the founding, it refers to an individual right.
That was a pretty big departure from earlier decisions. But that's what Justice Scalia said in his 5-4 majority opinion. After Scalia addressed the militia clause, he took on disagreement number 2. What does keep and bear arms really mean?
We conclude that it means pretty much what it means today, to have and carry weapons.
Scalia got that particular part wrong, that he just blew it in terms of the meaning of bear arms.
Dennis Barron is a leader in the field of corpus linguistics, which I mentioned earlier. All it means is that scholars and researchers gather up tons of sources. I'm talking like every single piece of text written in a given time period. Then they analyze how exactly a term was used and understood in that time period. Now this becomes important because Scalia was an originalist. He said the court can only interpret what the Constitution literally says, and only how voters would have understood that language at the time that it was written.
We argued that bear arms always has a military context. As the historian Gary Wills said, one doesn't bear arms against a rabbit. But in 2008, the Supreme Court said no, bear arms simply means tote a gun. And they're wrong.
Professor Barron's analysis didn't sway the court in 2008, but he says the evidence is actually even more compelling now, because in the last few years, more comprehensive source collections and more powerful computer tools have supercharged his field.
I came up with about 900 individual, unique uses of bear arms. And of those 900, I found 7 that had nothing to do with a military sense, although 6 of them were ambiguous.
That's the argument he made in a current case in front of the Supreme Court, the New York Rifle and Pistol Association v. Bruin. It's challenging a law that requires a special application process to own or carry a handgun in New York City, which is almost never granted. Barron's new evidence is unlikely to sway the Supreme Court's 6-3 conservative supermajority, but corpus linguistics has added a new high-tech wrinkle to this 200-year-old debate. Now, like all constitutional rights, the Second Amendment is not unlimited. Scalia said exactly that in Heller. But since Heller became the law of the land, the next step is working through what limits the government is allowed to put on firearms. And if the New York case goes the way most experts think it will become that much harder for cities that want to limit guns to do so.